Good day, future MPAs, and to our Professor Docnes S. Chu. I am Zosielex S. Bellita. For our subject Theory and Practice of Public Administration, I will be presenting to you Article 171 Revised Penal Code for Falsification and Administrative Matter 2005-24-SC, the administrative case for falsification against Randy S. Villanueva. What is falsification? Falsification is the act of changing something such as a document in order to deceive people. Similar terms: perjury, manipulation, counterfeit, and corruption. What is falsification in the Philippines? The crime of falsification committed by the intentional spread of lies on anything stated in a document. Falsification is a felony penalized under Article 172 of the Revised Penal Code. Article 171 provides that an act of falsification is committed by making an untruthful statement in a narration of facts in a document. The elements of falsification by a public officer or employee or a notary public as defined in Article 171 of the Revised Penal Code are that the offender is a public officer or employee or a notary public. The offender takes advantage of his official position, and he or she falsifies a document by committing any of the acts mentioned in Article 171 of the Revised Penal Code. Let us know the different types of falsification of documents. First is the falsification of legislative documents or imitating any handwritten signature or rubric. Second, falsification of wireless, cable, telegraph, and telephone messages. Third, falsification of private, public, or commercial documents. Fourth, falsification of a public officer, employee, or notary. Fifth is the falsification committed by a private individual. Sixth is the falsification of a public document. And last is the falsification of a private document. Falsification of legislative documents or imitating any handwritten signature or rubric. It is the common form of falsification punished under the Revised Penal Code. It is an act whereby a person who without proper authority alters a legislative bill, resolution, or ordinance enacted or approved or pending approval by either House of the Legislature or any provincial board or municipal council. Falsification of wireless, cable, telegraph, and telephone messages. It is an uncommon type of falsification, presumably due to the nature of the acts being punished. The offender in this case is limited to any officer or employee of the government or any officer or employee of a private corporation or entity engaged in the service of sending or receiving wireless, cable, or telephone messages who utters a fictitious wireless, telegraph, or telephone message of any system or falsifies such wireless, cable, or telephone message. Third is the falsification of private, public, or commercial documents, or the more common type of falsification. This involves the commission of any of the following acts: counterfeiting or imitating any handwritten signature or rubric, causing it to appear that the person have participated in any act or proceeding when they did not in fact so participate, attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. Fourth is making untruthful statement in a narration of facts, altering true dates, making any alteration or intercalation in a genuine document which changes its meaning, issuing an authenticated form of a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to or different from that of the original. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. The nature of the offense will depend on one factor: whether the person that committed the act is a public officer, employee, or notary, who's taking advantage of his official position, or a private individual. Fourth is the falsification committed by a public officer, employee, or notary. It has the higher penalty of prison mayor when it is imposed. It must be noted that to be liable, the act must have been done by the person taking advantage of his or her official position. Fifth is the falsification committed by a private individual. So the penalty of a prison correctional in its medium and maximum periods and a fine of not more than 5,000 pesos shall be imposed upon any private individual who shall commit any of the falsification enumerated in the next preceding article in any public or official document or letter or exchange of any other kind of commercial document. Any person who to the damage of a third party or with the intent to cause such damage shall in any private document commit any of the acts of falsification enumerated in the next preceding article. So in continuation, the revised penal code did not give an exact definition of what a public document is and a private document. So Section 19 of the 2019 Revised Rules on Evidence actually made a clear and categorical difference between the two. So Section 19 states the classes of documents. For the purpose of their presentation in evidence, documents are either public or private. So public documents are the written official acts or records of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or a foreign country. Documents acknowledged before a notary public except last will and testaments. Documents that are considered public documents under treaties and conventions which are in the force between the Philippines and the countries of source. Public records kept in the Philippines or private documents required by law to be entered therein. 6 is specification of a public document. So what is a public document? It is a notarized or consularized document. What is an official document? It is a document which is used by the government or any of its agencies or instrumentalities in the course of their official functions. So the penalty, mode of commission, and elements are the same. If the document involved is either a public or official document, so the crime committed by the offender is the crime of falsification of public or official document. 7 is the falsification of private documents, so or it is called the crime of falsification of private document. So it must be proven that the person committing the falsification did so the damage of a third party or with the intent to cause such damage. The element of damage or intent to cause damage must be proven beyond reasonable doubt for a person to be liable for falsification of a private document. However, pecuniary injury or profit by the person committing the falsification of a private document is not necessary. Let us know the penalties for the different classes of falsification. So for private, commercial or legislative document, and wireless telegraph or telephone messages, the penalty is prison correctional or imprisonment ranging from 6 months and 1 day to 6 years. For public officer, employee, notary, and ecclesiastic minister, the penalty is prison mayor or imprisonment ranging from 6 years and 1 day to 12 years. These penalties are in addition to the fine that the law imposes on the offender. Let us discuss a case of falsification. It is called AN number 2005-24-SC or the administrative case for falsification against Randy S. Villanueva. So, Republic of the Philippines Supreme Court, Manila and Bank AN number 2005-SC dated August 10, 2007 regarding the administrative case for falsification of official documents and dishonesty against Randy S. Villanueva. Resolution. This is an administrative case against respondent Randy S. Villanueva, Computer Maintenance Technologies 2 of the Court Management Information System Office or the MISO for falsification of public documents and dishonesty. Claiming that his application for employment abroad has been approved, so the respondent tendered his resignation effective September 2, 2005. It was approved on August 31, 2005 on the favorable recommendation of Attorney Ivan John E. Oy, the Chief of MISO. However, in a memorandum dated September 22, 2005, two Deputy Clerk of Court and Chief Administrative Officer Eden T. Candelaria raised doubts about the reason offered by the respondent and the timing of his resignation. So it is based on the preliminary inquiries of the Office of the Administrative Service or the OAS. So there were already 3 employees of MISO who were dismissed from the service for dishonesty and falsification of official documents. So first is Mr. Noel Luna, former SC Chief Judicial Staff Officer, was dismissed on December 15, 2003. Mr. Benjamin Catley, former Information Technology Officer 1, was dismissed on March 25, 2004. And Mr. Reynaldo B. Generoso, former SC Supervising Judicial Staff Officer, on August 25, 2005, was also dismissed. So surprisingly, 6 days after the decision of the case of Mr. Generoso was released, Mr. Villanueva offered to resign. So respondent was one of the employees authorized to render overtime services for the period January 2, 2003 to December 31, 2003. This is despite earlier information that he was enrolled at the Asia Pacific College. Based on the daily time records or DTR for the year 2003 of the respondent, he has always made it appear that he rendered overtime services every Saturday although he was enrolled at the Asia Pacific College. This appears to be an administrative liability on the part of the respondent for falsification and dishonesty, based on the records that the office has discovered. However, since the resignation of the respondent has already been approved prior to the discovery of his matter, the case was sent to the Supreme Court to leave the matter to His Honor's sound discretion. So, because of these doubts, the OAS did not release the notice of acceptance of resignation of the respondent. In a memorandum dated September 29, 2005, the approval of his resignation was recalled and revoked. He was directed to show cause why he should not be dismissed from the service for falsification and dishonesty. So on October 12, 2005, the respondent stated the following in response to the charges against him. First, the August 31, 2005 approval of his resignation should be deemed final, and the time he was required to answer the charges the court no longer had the authority to revoke its earlier approval of the resignation since no investigation was pending or initiated at the time he filed his resignation until it was approved and became effective. Second, he was enrolled at the Asia Pacific College only on June 10, 2003, so the accusations for the months January to May 2003 is without factual basis. In addition, there are two Saturdays wherein there were no classes because they fell within the semester break. Even the DTRs presented do not show that he collected overtime pay for all the Saturdays in 2003. It shows only 18 Saturdays. Third, he was enrolled in a masteral degree classes on information management and as such, he was not required to be present all the time in the classroom. Since the classes were focused on the uses of capabilities of the internet, he did his schoolwork from his house and submitted them by email. They also used the internet for discussion. Hence, it does not follow that his classes automatically prevented him from rendering overtime services on Saturdays. This happened 2 years ago and his documents are no longer intact to help him substantiate his service on the rest of the Saturdays. Fifth, he would not risk his job and reputation for the minimal amount paid for the overtime service. So the charges against respondent consist of the following. He made it appear in his DTR that he rendered overtime service on Saturdays in the year 2003. He collected the overtime pay of 100 pesos per day despite being enrolled at the Asia Pacific College and had whole day classes on Saturdays. The OAS in its memorandum dated November 8, 2005 discussed that the arguments of respondent were untenable. So acceptance of a resignation tendered by an employee is necessary to make the resignation effective. Second, starting from January 2, 2003 up to December 31, 2003, respondent had been granted authority to render overtime services and in fact collected payments thereof. Third, if Saturday classes need not be attended at the time because of the use of computers and the reports, and all that was required of him to be made through the internet, then he should have presented evidence of the in support thereof. Fourth is the amount is not an issue in the case at bar, but his propensity for committing the imputed acts. Fifth, that he had no more documents to help him substantiate the services he rendered, merely stands to show his failure to controvert the evidence presented against him. So, it commended that the respondent be found guilty of dishonesty and falsification of official document, and as a consequence, that he be dismissed from the service with forfeiture of all his benefits except the earned leave credits. So agreement with the OAS that the court retained administrative authority over the respondent when the approval of his resignation was revoked or recalled and the notice of acceptance was not served on him. There was no acceptance of his resignation because its approval was revoked and the final conclusive act of its acceptance, which was the notice of acceptance, was withheld. Open quote, resignation is not and should not be convenient way or strategy to evade administrative liability when a court employee is facing administrative sanction, close quote. There was a substantial evidence that the respondent made it appear in his DTR that he rendered overtime services on 18 Saturdays from June to December 2003 while he was attending classes. So this falls for the falsification of official documents. Falsification of an official document such as daily time records or DTR is considered a grave offense. It also amounts to dishonesty. Wherefore, the respondent was found guilty of falsification of official document and dishonesty. He is ordered dismissed for the service with forfeiture of all benefits and privileges, except accrued leave credits, of any with the prejudice to reemployment in any branch or instrumentality of the government, including government-owned or controlled corporations. So ordered by Puno, C.J. Kisumbing, Inares Santiago, Sandoval Gutierrez, Carpio, Austria, Martinez Corona, Carpio Morales Ascuna, Tinga, Chico Nazario, Garcia Velasco, G. Natura Reyes. So that ends the administrative case of pacification against Mr. Randy S. Villanueva. So before I officially end my report, I will share to you a quotation. Open quote, truth is everywhere, but somewhere it may be covered by falsification. But it may not be longer. Truth is forever. Close quote by Hani Praveen Barin, Kakinada, Andhra Pradesh. This is Zosielex Bellita. Thank you and God bless.